Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar where we're going to be discussing laws that protect information. A couple preliminaries before we get started on the actual presentation. If you are interested in the PowerPoint that we use for this session, you can find it on our website under the Training tab. Click on that and there will be a secondary tab that will take you to a page with all of the PowerPoints that we use for these webinars. You're welcome to download those and use them for your own reference, or if you're conducting localized training, they may prove helpful with that. Also, these sessions are being recorded and the recordings are available for distribution to any of your colleagues or coworkers that might not be able to attend this morning. What you can do is send us a flash drive, mail it to our address, and include a self-addressed stamped envelope, and we'll be happy to make and include a note which session you want. And we'll be happy to make a copy for you and mail it back. Turnaround lately has been about a week or so. So like I said, we're more than happy to do that for you. Unfortunately, we're unable to email them or post them on our website because the file size is so large that it causes problems with the email security protocols that are in place. We can only send files that are so big, and unfortunately, these files exceed that maximum. As you can guess, this session is PowerPoint based with me narrating. If you have questions, you can type them in the meeting chat feature. I would ask that, number one, keep your questions on topic. We're talking about laws that protect information. And secondly, try to keep your questions as short and direct as you can. Occasionally, folks will type in, several paragraphs or what seems like a whole page. And it's just awkward for me to sit here and have to read through that while everyone else is waiting patiently. If by chance, you are dealing with a particular situation that is unusually complex or just unique to your setting, we'll do one of two things. We'll wait until the end of the presentation and I'll be more than happy to address it then, or we can take the conversation offline. The phone number for the office is on the screen right now, as well as the URL for our website. And on the website, there are email accounts that you can type in your questions, and if our administrative staff can't address them, then they'll more than likely get directed to me or another senior staff member who can, at the very least, get you headed in the right direction. A couple caveats, if you're a requester, we can't write your requests for you. If you're an agency, we can't write your responses for you. And we certainly can't predict how an appeals officer will rule on a specific set of facts. In particular, if you ask me, I'll probably get it wrong. But what we can do is steer you to our website where we have what's called a docket search, where every decision that we've written since 2009 is in a searchable database. And chances are, the factual situation is very similar to something we've encountered before. And, we can steer you towards that, and you can get an idea as to how we've ruled on similar decisions in the past. And hopefully that'll get you, like I said, headed in the right direction. Okay, a couple things related specifically to this presentation. We're dealing with a number of laws that we've encountered here at the Office of Open Records that have been considered related to whether or not records can be withheld from the public domain. It's not all encompassing. Okay, these are the most frequently encountered ones that we've come across here, and also ones that have been suggested to us. There are others, like I said, it's just that they don't come up that often here at the Office of Open Records, so we've chosen to just focus on the more common ones. Yeah, I guess that's what needs to be said here. There is kind of a lack of continuity, and I apologize for that because of the different subject areas. So, we've tried to group them as logically as possible, but, like I said, I do apologize for jumping around a little bit. Okay, so all that being said, let's go ahead and jump into the presentation and talk about these laws. But first, I want to talk about just why this is important. And you have to understand a little bit about the right to know law itself and the appeal process. So first offhand, under the right to know law, with the exemptions that exist within it, they are not mandatory. Those exemptions do not say that if a record falls within the definition of an exemption, the law doesn't say that the agency must withhold those records. Okay, and it's interesting because we do occasionally get questions, must I withhold this record under the right to know law? And the answer is no, because it's discretionary as far as the agency is concerned for most of these records that fall within the exemptions. Meaning that even though a record is clearly captured by the definition of an exemption, the agency still has the discretion to release that record if it believes it's in the public interest to do so. So this is kind of referred to in Section 306, where it says nothing in this act shall supersede or modify the public or non-public nature of a record as established by federal or state law. Okay, so this takes us out of the right to know law and into the realm of these other laws that protect information. Because you're going to find in most cases, these other laws remove the discretion that the agency would otherwise have under the right to know law. So you could have a record, an example. Let's say it's a medical record regarding a public employee. Technically, if it's in the possession of the municipality, under the right to know law, even though it clearly falls under an exemption, the right to know law would allow them to release that record. However, when we take a look at the other laws that protect information, that discretion is removed because there are other laws that say you cannot release medical records for public employees or anyone for that matter. So you see how this all works, which brings us to the second point as to why this law is important, because it is the agency that bears the burden of proof as to why a record should not be released into the public domain. And they need to meet that burden both legally and factually. So if we look at the right to know law, the agency has the discretion to release. But if we look at another law that maybe doesn't have or doesn't allow that discretion, that says you must withhold these records, the agency can refer to that law and its appropriate provisions in meeting its legal burden of showing why the record should not be released into the public domain. So, and I can do both. I can refer to the appropriate exemption within the right to know law and exercise that exemption, meaning I'm choosing not to release the record based on that exemption. But then I can also point to these other laws that also say you cannot release these records under usually some sort of sanction. Okay, so that's important from the agency perspective in meeting your legal burden as to why the record should not be released into the public domain. Okay, so you see now why we're focusing on these other laws, because they play a very important role in determining whether or not a record is public or not. And if you've ever sat through the webinar that we do on basics of the right to know law, we do talk about this, that, if there is another law, it's part of that second hurdle, one of the hoops, the second hoop in front of the second hurdle, actually, where we say you need to be aware, is there another law that makes this record confidential? If so, you're off the obstacle course. Okay, so let's talk about some laws specifically. The first one, and probably the one we most frequently encounter, is called CREA, the Criminal History Records Information Act of 1980. And this applies primarily to law enforcement agencies. But it also can apply to any person that collects criminal history information. And if you look at CREA itself in the definition section, it will provide, an explanation as to what agencies, what individuals fall under the umbrella of a law enforcement agency as defined by CREA. Police departments, prisons, district attorneys, sheriffs, the courts, et cetera, et cetera. Okay, and it's important that we take a look at the definition section. And here's a perfect example, because CREA has a fairly well-defined definition of what a law enforcement entity is. Thus, you don't want to get confused with the definitions of law enforcement agencies as put forth by other laws. And I put this out there because there's an interesting one, Act 22 of 2017. I'm not going to talk about it specifically during this presentation, but if you're familiar with the history of public access to police videos, dash cam, body cam, security camera footage, Act 22 has a different definition of a law enforcement agency that, given a particular set of circumstances, can actually include a school district. And we've encountered this where under Act 22, a school district was defined or met the definition of a law enforcement agency. Clearly, under CREA, when you look at the definition section of that law, school district wouldn't apply. Okay, it's just what I recommend to anyone when you want to understand, truly understand what a law means and what it intends. Don't forget to look at the definition section, because that can shed a lot of light on those areas that might be a little, in that gray area where, if you have questions, if you're confused, go back to the definition section. And, I've used this for the Right to Know law, for the Sunshine Act, and clearly I think CREA and Act 22 are also good examples where, by reading the definition sections, you get a clearer picture as to what this law means. Okay, but back on point, talking about CREA itself. It protects criminal history, investigatory, and intelligence information. If you recall, looking at Section 708B16 of the Right to Know law, yeah, it covers criminal history and investigatory information, but it makes no mention of intelligence information. So conceivably, you could have a law enforcement agency that keeps a file on suspected gang activity within their jurisdiction. Okay. Under the Right to Know law, technically, I would have access to that file. It would be considered a public record. But because CREA covers intelligence information, I would rely on the appropriate provisions of CREA to deny public access to our intelligence folder. Okay, because you wouldn't want that out in the public domain. So these records then can only be shared with other applicable law enforcement agencies. And like I said, you'll want to know what an applicable law enforcement agency is, go to the definition section. Now, there is a very good resource for CREA published by the Pennsylvania Attorney General's office. It's on their website. The URL is available up on the screen right now. If you are working for a law enforcement agency, I'd highly recommend, download that guide, and it will prove to be a very helpful document for you. But you see now where we're coming from, number one, with these other laws that protect information, how it works, and number two, just a very good specific example, particularly if you're working in law enforcement, because this comes up a lot when people are requesting, for instance, incident reports, investigatory files, and the like, that the law enforcement agency will not only reference 708B16 as the legal basis for denying access, but they will also reference CREA in order to strengthen their legal position. Alrighty, so moving on. Somewhat related is Act 30 of 2016. This primarily applies to emergency call centers, your 911 centers, or if your law enforcement agency has local dispatch, it would apply to them as well. They're called public safety answering points, if you want to get into the technical jargon. But Act 30 protects any individual identifying information that may have been captured during the transactions that take place, whether it be, people phoning in to the 911 center or radio transmissions back and forth with the appropriate law enforcement agency or fire department, ambulance, rescue squad, whatever. Okay, and it's intended to protect any personal information of the person calling in, any potential witnesses that were identified, any victims. Okay, and this would include the name, telephone number, and home address would be, where we'd start as far as the individual identifying information. Now, it does not protect the information in general as it pertains to the location. Okay, so when we talk about address, for instance, I couldn't give out 333 Market Street, Harrisburg, as the specific address as to where this incident occurred. But I could, under Act 30, give out it occurred at the 300 block of Market Street. Okay, that would be appropriate. Or I could say the cross street of 4th and Market in Harrisburg. Or if we were out on an interstate or a state route, I could give the mile marker. It's just that I couldn't give the specific address out when it comes to a home address or the address of where the incident is occurring. Okay, so again, we routinely see right-to-know requests and to a lesser extent appeals related to people requesting recordings of 911 calls, recordings of the dispatch, and so forth. And Act 30 protects that to the extent that you would not give out this individual identification information or specific addresses. Okay, attorney-client privilege and attorney work product. Any communication of a sensitive nature between a lawyer and their client is protected by attorney-client privilege. For our purposes, most municipalities will rely on the legal advice and guidance of a solicitor. Okay, thus that legal advice and guidance, when reduced to writing, whether it be, a letter, a memo, email, even a text message, okay, between the solicitor and, let's say, a council or a board of supervisors or senior management, police chiefs and the like, would fall under this definition of attorney-client privilege. So all that communication is protected, and it's specifically referred to under Section 305 of the Right to Know law. And then we look at other laws. Attorney-client privilege is covered under the rules of evidence in Pennsylvania, where, again, this communication is considered confidential. Now, if by chance the communication is shared outside of the people involved with this specific relationship, let's say that the attorney meets with borough counsel in executive session to discuss a specific legal issue. And then one of the council people goes outside of that executive session and shares what was discussed. At that point, privilege has been broken and attorney-client privilege no longer applies. Okay, so you need, and this will come up periodically where, for whatever reasons, it's usually, internal politics related to the dynamics on that council, where or maybe it's just a mistake. You know, somebody accidentally shares privileged information. Okay, so then privilege is broken and you can no longer claim it. Invoices, that comes up fairly common. Someone submits a right to know request. They want to see how much the borough or the township or the city is paying for legal services. So they request copies of the invoices. Okay. So then the question comes up, well, can we release those? And the answer is, are the invoices of such detail that they may reveal attorney-client privilege? So our advice when we get these questions is usually first talk to the solicitor to get their take on it. And they'll usually do a fair job, okay? And sometimes it may simply be a matter of redacting certain information. But if you have, let's say we look at the invoice, and by looking at that, you can discern legal strategy. Let's say that the attorney is working on a case where someone is, suing the municipality, and their invoice goes into such detail. I spent 3 hours looking at case law related to XYZ. I spent 2 days interviewing potential witnesses, some, of an expert nature. Okay, well, by seeing that level of detail in the invoice, I can say, okay, the solicitor is taking this strategy with this legal case. Then I think it would be fair to say that that is protected by attorney-client privilege. If, however, let's just say that the solicitor says, for this month, I'm billing you, X number of billable hours, and that's it, well, then there is no discernible legal strategy. And that invoice would not be covered by attorney-client privilege. And we would argue, or I think most would argue, that it is a public record. It's a simple invoice, and it shows how much you're spending on legal services for that month, that quarter, or whatever. Okay. But again, if you want to tie this all back to the right to know law, Section 305A2 would be your specific reference. Okay, as promised, I'm jumping all over the place, and this is another one that comes up, I'm going to say fairly routine. I get a lot of questions on this from agencies. They get requests primarily for building plans. Okay, so they want to know, can we release these? And I'm going to say 2 or 3 times a week inquiries come in. And it's the Uniform Construction Code, what we call UCC. It is Pennsylvania's statewide building code. It applies to any agency possessing building permit applications, plans, and associated records. UCC became effective in Pennsylvania in 2004. And I'm old enough to remember before that, where Pennsylvania had a patchwork of building codes that was enforced at the municipal level. You had, there was a code called BOCA that a lot of municipalities had. There was the life safety code that dealt primarily with building egress and fire safety issues, et cetera, et cetera. Okay. Well, all that was standardized in 2004, but it wasn't grandfathered. So if you have building permit applications that predate the UCC, then you need to go back and look at, okay, what building code was in force? And you would take a look at the confidentiality provisions, if there were any, as to whether or not a record could be released, including the application and any associated building plans. Okay, now, let me distinguish. The application and anything submitted with that application or used in consideration for approval would be considered confidential under UCC. The approved building permit, however, that was issued by the municipality is a public record. Okay, that would not be withheld. Now, to clarify a point that comes up, The Office of Open Records in 2012 issued a ruling. It's called Ness versus York Township, where based on language both that is and is not in the UCC as it relates to the privacy provisions of records, we determined that residential properties also apply, not just commercial properties. So under UCC, you can use that language and our ruling as precedent to say that we are not going to release building plans for residential properties. I've had some debates with code enforcement officers over this. However, this language has stood for 10 years. It's never been challenged or successfully challenged, I guess I should say. So if you have questions about that, refer back to Ness and you'll see our logic as to how we extend that language to cover residential as well as commercial properties. And let's say that a citation was issued relative to a building code violation. If that citation results in either criminal or civil litigation, okay, that is a court record. And while it may not be accessible under normal circumstances related to the right to know law, it is possible then or probable that you would be able to get the records of that litigation because they are court records. And you could go to the court under their 509 process, Rule 509 process, or just, approach the courts directly to see whether or not those records are available, and you'd be able to get anything related to, that legal dispute. Okay, and just finally to clarify, what we're talking about here are building permits. We're not talking about zoning permits or zoning variance applications. That's covered by the municipality's planning code in Pennsylvania, not the UCC, and it's a different world outside of the realm of the right to know law. Okay, so if you're interested in zoning hearings or anything like that, take a look at that law to determine the whether or not certain records are public or not. Okay, questions popped up. Is there a specific section of the UCC that should be referenced when denying access to plans? Yeah, I don't know it off the top of my head, but there is a specific section in UCC that covers access to records that are used in the approval process, in the application and approval process. Don't know the numbers off the top of my head, but if you take a look at this final determination that's available on our website, pardon me, that will steer you to the appropriate provisions in UCC. Okay, moving on. Now I want to get into healthcare related laws because this comes up. People requesting health related records. It's surprising how much this comes up, and people think that they can get access to this stuff. When, if anything, I think this is probably one of the strongest areas of privacy, both within the right to know law and these other laws that are available. The first one I want to talk about is probably the most commonly known one. It's the Health Insurance Portability and Accountability Act of 1996, or what we typically call HIPAA. HIPAA applies primarily to healthcare providers. It doesn't typically apply to employers. But we mention it because you may still find municipalities who either directly or through contractual relationship are providing healthcare, whether it be through, like a senior program or, a facility that's providing medical services to indigent or, income-related circumstances. So if either directly or through contract, they are in possession of personal health care information, they would not be able to release that under penalty of sanctions as determined by HIPAA. Okay, HIPAA says individually identifiable health information is off the table. It is not in any way considered a public record. Now, if you have an employee of a municipality, they can voluntarily approve the release of health information. And I'll talk about a potential scenario here when we're dealing with another health-related law. Okay, but if that employee voluntarily approves the release of health-related information, the employer must keep that information secure. Okay, it can't like go in the personnel jacket of the employee. It must be kept separate and it must be kept under lock and key, and only a very small number of staff would have access to that information. Okay, so another law, health-related, is the Family Medical Leave Act, or what we call FMLA. Now, this does apply to employers specifically, and human resource leave administrators and direct supervisors. And this protects any leave or accommodation-related record that could disclose the presence of a serious health condition. Okay, so this is, like I said, directly employer related, and it primarily would cover that information of their employees. And we mentioned leave specifically because that's where you've got accommodation related leave and family related leave. Your paternity and maternity leave falls under this. The thing is that by looking at an employee's leave record, it's possible you could conclude that the employee has a serious health condition. So that's where you need to be very cautious about what leave information you release. And again, this has come up through right to know requests where you've got a nosy neighbor and their next door neighbor is a public employee, but they've been home all week, like they're out mowing the grass and stuff. So this neighbor submits a right to know request to the township. I want to know what leave this employee has been taking. Are they on the clock, I guess, while they're mowing their grass or whatever. Yeah, I know, but you see this out there. So let's say that the employee is actually, I shouldn't have mentioned mowing the grass, but let's say that they were off 3 consecutive days on sick leave. Well, if you're familiar with FMLA, if you work in HR, what happens? If you've got an employee taking sick for 3 or more consecutive days, you have to send them a survey asking them, is this leave related to a serious health condition? And if they indicate yes, then that leave gets charged to their FMLA balance. Well, if you were to release that information, you're divulging the fact that this employee has a serious health condition. And you're then subject to sanctions under FMLA. And those sanctions, could get serious. So you want to be careful about any leave information that you release related to a right to know request. Okay, but information can be provided to supervisors and those who have a need to know basis, such as first responders. So you have an employee who suffers from epileptic seizures. They notify their immediate supervisor, hey, this is my serious health condition. So if by chance I do have a seizure and you need to call an ambulance, you can tell the first responders that I've been diagnosed with epilepsy. Okay, you can do that. But again, the supervisor must keep this information confidential and only reveal it to those who have a need to know basis. Okay. Question has popped up. If an employee approves release, will that need to be done each time? Not necessarily. I think you've got to look at the specific situation. It could just be what I would call a temporary serious health condition or medical condition. Some of these, you would have to get familiar with both HIPAA and the Family Medical Leave Act to determine whether or not a serious health condition is in fact intermittent or temporary or permanent. Okay, and that would have a bearing on how the employee would authorize the release of that information. Because if it is a temporary condition, once that condition has exacerbated, once that condition is no longer present, I would then presume that the employee's approval of the release of that information would no longer be relevant. Okay, so I think it's best to have that communication back and forth with the employee. And some of this responsibility falls on the employee to notify the employer the specific circumstances under which they are approving the release of the information. Okay, so yeah, communication is important, but so is confidentiality. And I think this is a case where good communication can lead to a clear understanding as to what the expectations are, as to what is confidential and what is not. So yes, have that conversation, case by case basis. And I think that's probably the best way we can deal with your question there, Zach. Good question, by the way. Okay, moving on, first sip of water. Americans with Disabilities Act, or ADA. This also applies to most employers, and it deals with primarily accommodations for employees that suffer from disabilities, or that, I should say, have disabilities. I'm sorry for the politically incorrect wording there. So it protects all medical records and requires that they are stored separately from other personnel-related records. I remember when ADA came out, and at the time, in a previous career, I was an HR director for a large state agency. And when ADA came out, we had to go through all of the personnel records and remove any health-related information and store them separately under lock and key. And even as the HR director, I did not have access. Only my benefits staff could access these separate records that had anything medically related. Okay, now there is a set of circumstances, though, where an employee, again, can divulge a serious, really any medical condition that would require an accommodation. And that information can also be gleaned possibly from staff through a non-medical inquiry. And let me give you an example here as to, to help explain what I'm talking about. Our borough staff is in a building, multi-story, and we've appointed one of the employees as the building fire marshal. Okay, so this fire marshal is responsible for making sure all staff are evacuated in the instance of, a fire alarm. So they send out a survey. In the event of an evacuation, do any of you require any special help? And one of the employees notifies the fire marshal, I had surgery for a hip replacement. I cannot exit the building on the stairs by myself because of the lack of mobility, et cetera, et cetera. I'm going to need help. Okay, so the employee, through a non-medical survey, has divulged the fact that they have a medical condition that requires an accommodation. The fire marshal, who is non-HR, non-medical, is now aware of that. So, fire alarm goes off in the building. Everyone has to egress. The fire marshal has told the employee, as well as the assistant fire marshals, go to the stairwell in the fire tower and stage on the third floor where you work, and we will send the fire department up to get you. Okay, so that's how that would work. Okay, and the fire marshal then would only release this information to the fire department and those also on the fire evacuation team who would be aware of the special accommodation needed for this employee because of their medical condition. All right, so again, communication and confidentiality both come into play. And I think this kind of goes back to Zach's question. You know, what if the employee through therapy reaches a point where now they can walk down steps? Then the conditions would no longer apply. And, well, you know, again, you'd look at it on a case-by-case basis as to what's considered confidential or not. And in this case, you know, the what we'll call the temporary disability is no longer relevant. So you don't have to worry about anything as far as confidentiality goes. Okay, so, but again, all sensitive information, all protected by laws that could result in a sanction if you either knowingly or in some instances unknowingly release this information outside of the approved context of people that have a need to know basis for having access to this information. All righty? Okay, completely jumping ship now to FERPA, the Family Educational Rights and Privacy Act. This applies to schools. Okay, here we're talking about individual educational records. So public and private schools could be primary, secondary, or colleges. And you know, when we talk about individual educational records, we're talking about grade reports, report cards, transcripts, as well as discipline information related to individual students. Now, you're thinking, okay, well, our newspaper publishes the school honor roll. Or, you know, what about sports? You know, sports is, you know, part of the individual record of a student. Well, there's a thing called directory information that's covered by FERPA that allows the publishing of, you know, that general sort of stuff, and it's okay. Also, any aggregated data where by giving it out in such a way that it can't be sliced and diced so that you can drill down to see individual students. And I'm emphasizing this point because in recent years, there have been right to know requests seeking COVID-related data in schools. And it has to do with, you know, lockdowns, online classes, masking policies, and the like. So, you know, just this week, I was dealing with a phone inquiry from a school board, or actually a school superintendent. You know, they got a right to know request for COVID data. And I had this conversation. If you can give out the aggregated data in such a way that it will not identify specific employees, then you can release it. The concern was that some of the schools were very small, and even with the aggregated format, someone who knew the classes and knew of the students could probably identify who was diagnosed with COVID, which in that instance, because it is an individual educational record, yes, health records of students are considered part of that. You could identify the individual student, therefore you could make the case to withhold it, whereas in other instances, you could not drill down deep enough to identify individual students. So that information would be released. Okay, so when you're dealing with aggregated data, grade reports for, you know, an entire grade, how did they do on this state mandated testing program? Okay, that is public, but if it can be reduced down to the individual level, then it would not be released under FERPA. Now, what about the parent that wants to see grades for their particular child? While you would not have access to that under the right to know law, FERPA does have a mechanism available for parents and guardians to see those grades. Okay, what's unfortunate is that a lot of districts will reply to a right to know request, by simply denying it. FERPA says we can't give this out. What they fail to do is let them know that there is a mechanism available in FERPA for the parent to see these. Okay, so again, communication is key for getting around, these misunderstandings when it comes to what is public and what is not. And it's quite common for us to encounter situations where, yes, this person is entitled to these records, just not through the right to know law. There is another mechanism available to them. Okay, and I think part of the responsibility falls on the agency to let the requesters know what those processes are. Okay. Getting into a little more detail here, law enforcement, campus police records are not protected by FERPA, so that if you have a college student who runs afoul of the law and they get charged or whatever, those records are available under right to know, as well as possibly as court records. When it comes to videos captured by school districts, this is an evolving area of the right to know law. There have been a number of rulings, both from our office and the courts, getting specific as to what records can be released, what records can be withheld. Take a look at, again, our final determinations database, or what's called our docket search on our website, as well as our case law index on the website that will show you what the courts are ruling on this. I cannot give you like a standard rule of thumb. I think you've got to take a look at these rulings, look at the specific facts surrounding the decision, and then look at the logic that either the appeals officer or the court used in determining what records are confidential under FERPA, what records can be released. And, I think that's the best we can do at this point, because it is very fact specific in how case law is evolving here. And then finally, I used the example earlier about COVID. Student health records are covered by FERPA. If there would be a dispute over health records being released, the standards for FERPA would apply, not necessarily any of those health-related laws that I indicated earlier. Okay, the Pennsylvania Public School Code, this kind of reinforces FERPA on a local level. It applies to all public school employees and officials. And again, I mentioned health records because you could have health-related data on students being collected at the school level, like through a school nurse or a medical practitioner of some sort. Well, those medical records fall under the purview of FERPA as part of the individual educational record, so that if you were to receive a right to know request, you could use FERPA as your legal basis for denying access to the student health records, because the health records are considered an extension of the educational record per language of agreements at the federal level. Okay, jumping around again, the PA Motor Vehicle Code. Doesn't come up that often anymore, but we saw, questions popped up. Does FERPA also protect records like home addresses of students and families? No, not necessarily, but they would clearly be protected under what's known as the Pennsylvania constitutional right to privacy. And Jessica, there is a string of case law available on this that goes back to the original case was the Pennsylvania State Education Association versus Pennsylvanians for Union Reform, that dealt with should the home addresses of public school teachers be released. Okay, that's where it all started. And the Supreme Court said no, there's a constitutional right to privacy for home addresses to be protected. So then that resulted in an expansion of the right to privacy through various court rulings, as well as final determinations issued by our office, where basically our recommendation now is that wherever there is a concern over privacy, you need to do what's called a balance test. You weigh the person's constitutional right to privacy versus the public interest in knowing that home address. And in most cases, it falls on the constitutional right to privacy in withholding that information. Okay, but what if they are taxpayers? Are taxpayers' name and addresses allowed to be released? Oh boy, this is a tough one, Janine, because under the right to know law, that information is protected. But let's say the easiest way to get home addresses is through the election registration process. Okay, there it is public. And that supersedes the right to know law. So while I say that the records are protected under the right to know law, if you receive a right to know request, our recommendation is to redact that information. If you're really savvy with public records, though, you could look at the voter rolls to see what a home address is. Or, let's be honest, you could just Google it. I mean, you can Google my name, and within the first 5 hits, you'll get my home address. Okay, it's there. But, we look at the right to know law, and the right to know law, the perspective is we protect personal privacy, that constitution. Okay, so yeah, I realize it's somewhat confusing there, but that's pretty much how we roll. Okay, some questions have popped up. I need to go over to that screen, and I'm going to back up because they're already off my screen. I want to make sure I don't miss anything here. Okay, yeah. So in what case will it fall under the public interest rather than the constitutional right to privacy? Do you have an example? Yeah, you've got to take a look at what are the circumstances that the home address could potentially be released. We had one where we approved the release of a home address of a public official because there were questions concerning residency, and you had to be a resident of the township in order to hold office. And we ruled there that it was in the public interest to know what was the home address of this public official. Just the backstory was he was going through a divorce, and there were questions as to whether he still lived in the township or not. Okay, but there was an example where we ruled it was in the public interest to know what his home address was as opposed to his constitutional right to privacy. Go back and read the original decision, and the court refers to a thing called a balance test that must be conducted. Okay, and that will give you an understanding as to what the municipality needs to go through in determining whether or not the constitutional right to privacy prevails. Okay, beyond that, I don't want to get into the weeds too much, but good question. If someone requests a tax report, okay, well there it's going to come down to number one, the constitutional right to privacy. Number two, does the agency actually have possession of the tax report? Because you're getting a little bit ahead of me, but I might as well talk about this now. Under the Pennsylvania tax code, tax collectors are not subject to the right to know law. But if the tax collector has given a report to the municipality and the right to know request is submitted to the municipality, then it can be released. But again, the home address, you've got to take a look at. In most cases, I think we would redact the home address. But again, you're looking at that balancing test there as to whether that information can be released or not. Okay, let me get back to the motor vehicle code. All good questions, folks. I hope I'm answering them for you. Under the motor vehicle code, any record of a driver's qualifications can be withheld. You go to section 6114 of the motor vehicle code, and it basically says, any record of an individual's authorization to operate a vehicle. Well, that's your driver's license. So, and this used to come up, it has not come up, I'm going to say probably in the last 6 months, but someone submits a right to know request. They've seen one of their township employees driving a piece of equipment, and they have doubts as to whether they're qualified to operate that piece of equipment. Okay, so they want to see the license. Well, they can't get it because of this language in the motor vehicle code. Okay, and you get into CDL license, commercial driver's licenses, where, based on the type of equipment or the gross vehicle weight, you need a CDL to operate. Well, those CDLs are off the table. They're considered protected information because of this language in the motor vehicle code. Now, let's say that you do have a township employee who, got dinged for maybe a DUI, or they've racked up a bunch of speeding tickets. Well, those end up being court records, and they are accessible because they are court records, not motor vehicle records. So any record of a criminal sanction would be a public record. But the license itself, or any record of someone authorized to operate a specific piece of equipment on the road, would be off the table. Oh, I got to go back over to this other screen now to federal copyright law. This one comes up more than I'd like to realize. Oh, will the following be considered an individual insurance policy number, VIN number, license plate number? I think there, a lot of that information is protected. Not so much the insurance policy number. I think insurance policies for municipalities would be protected. VIN number for a piece of equipment and the license plate number, there I think you've got to take a look at the motor vehicle code as to whether or not that information is protected. Off the top of my head, I don't know, Zach. Yeah, I just don't know. Okay, federal copyright law of 1976. This will apply to really any record in the possession of a municipality where the author is claiming individual thought. It typically comes up with site plans, building plans that might be submitted by an architect or engineer. Now, let's say we're looking at a blueprint and we're talking about a new subdivision. All right. Well, the architect or engineer will typically affix one stamp to it. And that stamp is really the licensure stamp. It says, I am a chartered engineer. I'm legally authorized, or I'm sorry, I'm a licensed engineer. My European background is coming out here. I'm a licensed engineer. I am legally authorized to draft plans like this, okay? But what you need to look out for is whether there's a second stamp on there where the engineer is claiming, oh, and by the way, this blueprint and the ideas on here are so unique, so great, that I am claiming original thought, that and that I am copywriting these plans. When you see that, the municipality can authorize, they can allow a requester to look at the plans, but they cannot make a copy of the plans, because that potentially would be a violation then of the copyright status that the engineer has affixed to the plans. Okay. Now, you can have implied copyright sometime, and I don't want to get into that aspect of the copyright law. But as it applies to the right to know law, you want to take a look at a case, again, in our case law index called Ali versus the Philadelphia Housing Finance Authority, where we get into all this. Actually, the court gets into it. So if it's a copyrighted record, the individual, the requester, can inspect the record. They simply cannot have a copy of the record, and that would include a cell phone picture. All right. But if they would somehow manage to snap a picture, maybe there's like an open house, or maybe they're going through right to know, any dispute arising out of the Federal Copyright Act is between the person claiming copyright, the architect or the engineer, and the person allegedly abusing the copyright. And taking a picture in and of itself is not necessarily considered abuse. But what I'm trying to say is that if someone were to take a picture of it, the municipality bears little, if any, liability in that particular case. But, take a look at that legal decision if this comes up. And that's how the copyright law applies. And simply because there is a licensure stamp on the blueprint does not indicate copyright. Okay, copyright is a second stamp or indicator usually on there. And, if you happen to be an engineer or you're dealing with these blueprints, I want to caution you about using a copyright stamp for plans that represent basically an industry standard. Like I saw a copyright stamp on a blueprint for a stormwater runoff plan where, all that is predicated by code and industry standard practices. As a matter of fact, if you were to vary from the industry standard practices, you might find yourselves getting into trouble, especially if your stormwater plan isn't effective. Okay, so, to claim that an industry standard is original thought, I think is quite a bit of a stretch, and you might find yourself getting into trouble over that. All right, moving on. Child Protective Services Law. This applies to anyone who in the course of their employment comes in contact with children. Okay, municipalities, well, yeah, you could have social services directed to child care or some sort of child services. You could have a summer playground program for kids and volunteers running it. But nevertheless, it's on, municipal park property or whatever. Well, those volunteers fall under the umbrella of the Child Protective Services Law. So if they suspect any sort of abuse involving one of the children, they're under a legal obligation to report that suspected abuse. It results in an investigation, and anything related to that volunteer reporting the suspicions and the investigation that takes place, any summaries, any evaluations, et cetera, all fall under the umbrella of the Child Protective Services Law, and thus they are considered confidential. Okay, and as a matter of fact, anyone initiating an investigation is treated under this law like a confidential informant. So the bar is raised quite high. And it also applies to child abuse history clearances. The child line approvals that we need to get whenever we're dealing with kids. Okay, all that information is protected. Okay, so I get phone calls, I see right to know requests from parents involved in custody disputes. And somewhere along the line, someone has filed a child line saying they think this child is being abused. Okay, so the parent wants to know, number one, who filed the complaint? Number two, what's the status, et cetera, et cetera. Okay, very ugly, very frustrating, but nevertheless, this is where this law comes in and mandates that this information cannot be given out. Okay, you just have to kind of calm the parent down and say, look, there's nothing I can do because of this law. They're going to have to get an attorney, subpoenas, et cetera, to deal with the custody issue. Okay, it's outside of your hands. There's nothing you can do because of the language in this law. Somewhat related is the Older Adults Protected Services Act. Now, this only applies to employees and administrators of elder care facilities, but you still have facilities directly or contractually that are run by municipal governments. So it is possible that that nexus exists for access to these types of records through a municipality. This law takes those records off the table. It protects all reports of abuse or neglect, all investigatory materials, and any assessments and service plans that are put in place as a result of the investigation that takes place. Okay, so this law, number one, the adult needs to be over 60, and number two, they need to be of such a medical or mental or physical state that they can't take care of themselves. All right, so the employees of this elder care facility, whether it be a caregiver or an administrator, are the ones who the law specifically applies to. Again, they could either be through contract or directly employed by the municipality, that they cannot give out any of these records. Disease Prevention and Control Act of 1955, we hopefully are seeing the light at the end of the tunnel for COVID, but during the last 2 years, this law was in the headlines a lot because of people wanting to know like infectious rates for various geographical areas or municipalities and the like. It applies to your county health boards as well as the Pennsylvania Department of Health. And essentially what it does is protect any reports of disease, reports of actions, other records from the release of data outside of these boards of health. Where the disputes have come up is aggregated data versus individual data. Okay, let me just put this fairly here, and I think I'm giving everyone a fair shake. The boards of health have said that this law protects all health-related data and we cannot give it out. The Office of Open Records and most of the court decisions that we have seen had said, no, you must give out aggregated data. Okay, we understand the individual health-related data, but aggregated data. Battles are still going on. Okay, it's not a closed issue yet, but I think that pretty much captures the positions of the various sides on this. And we'll just see how it plays out. Hopefully we will never encounter a situation like this again, but never say never. But that's, the Disease Prevention and Control Act of 1955 is why we're not seeing specific COVID-related data on a geographic basis within Pennsylvania and slicing and dicing it down even further. All right, some random points that I think are important for the good of the order. Tax information. W-2s under the Federal Internal Tax Code are not considered, aren't considered public records. They're considered confidential. Still surprising, we see right to know requests. I want to see W-2s for all these public employees. No, you're not going to get to see them. On a local level, taxpayer bill of rights in Pennsylvania makes it a misdemeanor to release any confidential tax information that the agency may have come in possession of, whether it be public employees or residents or taxpayers in general. There's also a thing called the Local Tax Enabling Act, LT, which protects any information obtained from tax returns or investigations that a municipality may be conducting. And that would include, an extension of the tax collecting arm if there is like a tax collection bureau that the local municipality has contracted with. All of that information is considered confidential and would not be released under penalty of sanctions. And then what we were talking about earlier with the constitutional right to privacy. Again, this is this evolution of case law in Pennsylvania that is extending privacy rights to the public in general for any home address information and even dates of birth. Okay, your date of birth over concerns about stealing identity theft. Is considered confidential. Now, your month and year of birth can be given out for public employees because of information requested over pension plans. All right, and you get, competition for various firms wanting to manage pension plans. You get people concerned over whether pension plans are solvent or not. So they're requesting information on public employees as to, prospective retirement dates, et cetera, et cetera. The date and year of birth is considered public. The actual date of birth is not. That's considered confidential. All right, all under this umbrella afforded by the constitutional right to privacy. Okay, so we're at the end of the presentation. I've referred to our website a couple of times. Take a look at it. You're going to find a lot of useful information there, including what I referred to with our case law index, as well as our database for final determinations that we issued. Just a word of warning, there's like 30,000 and counting final determinations, but the database is searchable. You can put in random text strings and it will come up. Okay, question, home address release refer only to public employees? No, we're extending that. Whenever we get questions about releasing home addresses, we say, look, take a look at the specific context of the request, and if it makes sense to protect the home address of whoever the information about is being requested, redact that information. Incident reports for private citizens fall in that bucket. There, with incident reports, I'm assuming you're talking about police incident reports. I would suggest listening in on our webinar that we do on Right to Know for law enforcement. Police incident reports are not considered public records. Okay, they fall under what's called the B-16 exemption. They can be withheld, and that is also based on a court decision. These incident reports are not considered public records. Okay, other questions? Now's the time to get them in, or like I said, if something comes up, feel free to reach out to our office, and you know, we'll try and get you headed in the right direction there. But take a look at our website. You're going to find a wealth of resources on there for a number of things we've talked about here today. Payroll summaries have been requested at our municipality. Are you saying these are not for public viewings? No, I didn't say that. Payroll summaries could very well be considered a public record. What I did say is that W-2s are not considered public records because of the Internal Revenue Code. When it comes to payroll summaries, any expense that is borne by the municipality is considered a public record, whether it be gross salary, your net, the cost of benefits. However, if on the payroll summary, there is like a pre-tax discretionary selection that an employee has made, for instance, I have what's called a deferred compensation. I participate in what's called a deferred compensation plan, where X number of dollars are taken off the top of my gross salary and they go into a tax deferred fund. Okay, that is my choice. Thus, that would not be considered part of the public record. So it would be withheld from a payroll summary. If I were to participate in additional benefits at my own expense, and there would be a pre-tax benefit to doing that, that would not be considered public because it is me doing it at my discretion. Karen, I hope that kind of addresses your question there. If it's borne by the municipality, the public has a right to see how their tax dollars are being spent. That's public. If it's at my discretion as a public employee, that would not be considered a public record. Okay, good. Any other questions before we wrap it up today, folks? Hey, good questions. I appreciate that, and hope to see you participating in future webinars. Okay, thanks again, folks. I think we're going to log off now and call it a day. Take care.